And then we have Darla Guenzler with us, who is Executive Director of the California Council of Land Trusts, and she leads the Council's policy and law, communications, education, and research programs. Her extraordinary contributions to land conservation law and policy are many. She founded the California Conservation Law Forum. She drafted the first laws in the nation that protect conservation easements in the condemnation process. She has led numerous policy, research, and collaborative projects on improving the use and management of land protection and management tools, as well as developing regional conservation plans and funding strategies. She's written on the use of charitable trusts to protect natural resources. Her dissertation is on the use of easements to meet conservation easements to meet regulatory objectives. She was the first researcher to explore the stewardship of conservation easements, and it was one of the first things that I read when I began researching this field, and it was very, very well done and informative. She holds a PhD from the University of California at Berkeley in city and regional planning with a specialization in land conservation, land use planning, and environmental policy. And with
thank you, Nancy, for organizing this today and for the great discussions, and my fellow panelists. My title here today might be best called cat herder, since that is sort of the process or stage that we're in California with regard to developing a statewide policy for amending and extinguishing easements. And we have a process called the Conservation Law Forum, Nancy mentioned, that has been meeting since 2005, 3 or 4 times a year. Since mid-2011, has been working consistently on this amendment question and extinguishment question. And in another context, we also have been working with the California Attorney General's Charitable Division, dealing with developing and improving some rules of the road, if you will, through legislation for how the endowments for mitigation is handled. So we are very much, unlike Maine, unlike New Hampshire that you just heard, Vermont is also, many of you may know, has introduced some legislation as well. So California is in the midst of working with our Attorney General and bringing together many parties to develop what the policy in California should be. And I want to go through a few specifics. But before that, let me say, as Nancy mentioned, I'm the Executive Director of CCLT, and while I will characterize some of the conversations that we're having, although I'm going to stop short of saying exactly where that is, since we're very much in those conversations, that I am speaking for CCLT, and while I may characterize things, in no way am I speaking for either of the 2 divisions of the Attorney General's office that we're working with. So in California, we have more than 8,000 easements. The category that is, we know that there's far more. We have many municipality easements that have been created for mitigation purposes. A study that I did just of 9 counties found over 700 easements in those, and so we have a lot of work still to do to get those municipal easements, largely created for mitigation, into our database. We have a huge number of organizations that work on this in conservation easements very actively, nonprofit land trusts, but also more than 30 very actively vigorous agencies, state and regional, that are working and using conservation easements in addition to all the RCDs, local governments, and federal agencies. One of the challenges that we're working with, and kind of the complexion in California that underscores, I think, the approach and the value of the approach to develop some state responses to this, is that for the most part we purchase easements in California. Since 2000 alone, we've had more than $13 billion invested in land acquisition. Obviously not all of that is conservation easements, but that is the majority of the way that we protect. Secondarily is mitigation, and that is growing very rapidly. I mean, we have a lot of mitigation easements, but it's a very large body, and it's continuing to grow very aggressively. Relatively speaking, we have very few donations. So the question comes up, of course, and it was mentioned here earlier, about whether these purchased easements are subject to, and the mitigation as well, are subject to charitable trust law. In the same way, the charitable division of our Attorney General's office, like with our mitigation endowments, their view is it does not matter how they're created. These are restricted gifts, and I find this is a useful term to use. These are restricted in perpetuity for some charitable purpose, regardless of holder, regardless of how they're created. But that is far from widely shared yet in California. The easements, as we've mentioned here before, we're dealing with an unusual asset in that we have static, imperfect documents. We're trying to manage for complex conservation goals, a very dynamic landscape that is only going to become more so over time with climate change as communities build out and so forth. And we face, someone talked about it earlier, we face potentially we have the shared ownership and face opposition from the landowners that we're sharing rights to property in. So it does present a set of circumstances and that we have to grapple with. As Nancy mentioned in her opening, this is not a simple area. There's not broad agreement yet. And I think for many in the land conservation community, including the attorneys, they have viewed conservation easements as developing, as a tool that's developed within the conservation community, that they are a creature of real property law. And now the more recent work, and especially the involvement and more visibility of the attorney generals and some of the recent cases, have raised this charitable trust, that conservation easements are a charitable trust creature, not to mention the contract issues, which, like Nancy, are annoying when they're raised. But but certainly the realities, and I would argue that it's not, the conservation easements very much are simultaneously creatures of both. And we also have competing views and priorities that people differ on in terms of, is their view first and foremost to the charitable purpose, and what happens over time in terms of the kind of the lingering dead hand concept, and are we continuing to advance the charitable purpose for which, whether it was mitigation, whether it was purchase or donation, that those resources were made available to protect the property. In the interest of time, I'm going to skip through a few of these quickly. I wanted to talk a little bit about the kinds of what we're seeing in California in terms of the examples, and there's been a lot of talk today about swaps, and I wanted to bring up that we're not seeing large numbers of amendments, but we have seen a number of swaps. But it's also, what we're finding is not quite so clear cut as how we've talked about swaps here today, at least in our view. And that is that the land trust and other easement holders are presented with scenarios where other public purposes are needed. It might be a road safety, for road safety purposes, to expand, add a lane to a road, for pipelines that require some ongoing intensive management. And so the easy route might be to just allow partial condemnation of that property. However, that results in a net loss of total of the land that's protected for some conservation purposes. And what we've encouraged the agencies and land trusts to do is to, and our statute that we've got passed in California encourages this as well, for the parties to consult early. What we have found is, whether it's the conservation agency or land trust, by consulting early with the engineers at our Caltrans department or the energy companies that are putting up transmission lines, that we can often get those impacts and byway transmission lines or whatever it is moved onto other properties or minimized on the property if it has to go through the easement protected property. But in the end, rather than condemn the property, sometimes there's options, this is not always available, but sometimes there's options to augment and add on additional acreage to that property, again, that achieves those same conservation purposes, has the same features of what we're having to condemn. And we're viewing this as a net conservation benefit in the end, as opposed to losing, just an absolute loss. But again, we have to do this carefully to ensure that we're getting comparable lands in that swap. And I think what we have had as a worst case scenario, and consider an abusive case in California, is one in which there was an 1,100 acre easement. I've just been working on this past summer and fall, that was created for mitigation purposes. It was held by a nonprofit that was created by a for-profit consulting firm, which is the sole consulting firm for a very influential developer in California. That same developer owned the underlying fee. It just gets better and better. This is like my soap opera. Anyway, so they proposed to amend this easement to allow 40% of the easement to be covered by solar panels, and to forego an allowed gravel mine that did not exist, had never been applied for, but was permissible under the very poor quality easement in the first place. The nonprofit did not object to this, unsurprisingly, given who and what they are. This is an irreplaceable biological resource. This is a critical corridor between our best two remaining preserves for endangered kit fox in California. We just can't replace this corridor. And we got into a situation where the nonprofit was completely passive. The public agencies had enormous, overwhelming in the end, political pressure and direction that they had to allow this amendment. And so this is our example so far of kind of the worst case scenario we've seen. In general, we're seeing not large numbers of amendments. We have not seen widespread cases of abuse, but given my early work on easement stewardship, a lot of my career has been spent on anticipating what can come, but hopefully we all continue to be realistic and try to balance what we anticipate can come and trying to get rules of the road that work to protect the conservation values that we have, while also keeping this a flexible tool. There's been a lot of advances, many of you know, in terms of accreditation and professional standards. Many of our land trusts have developed quite sophisticated amendment policies in which they're doing 17, 18, 19 different legal, financial, and other tests in their analysis that went to the previous discussion about the kind of the analysis that you need to do in terms of exploring conflicts of interest and impacts of the project. The biggest concern in our conversation so far is about, again, we're looking at when it's necessary to amend or extinguish easements. How do we ensure that the conservation values for which those charitable and public resources were dedicated are protected? And the working group is agreed. We're not talking about the scenario that was presented earlier of a private developer would find it more efficient and cost effective to take his road through the property. Those kinds of things in terms of the private interest of other parties are off the chart. And something that we're not considering. Those are not what we're considering is allowable for the kinds of changes that may be needed over time. The other area that we have major concern about is the public agency, whether they're holding that easement or they have the authority and requirement to approve the amendment. And our grant agreements for years have all required when the state is funding it, that the state has to approve whatever that agency was that provided the initial grant or purchase. They must approve the amendment. And in the case of mitigation, it's normally whoever the one or more regulatory agencies are must approve the amendment. But in the local government case, they're very accustomed to awarding considerable private benefits, rights to develop property, et cetera, and the agencies just do not have the same kind of charitable and legal constraints that nonprofits do, and so we've really seen biggest problems there. And then, of course, the political pressure and having elected officials in a decision-making role that are so vulnerable to the political pressure. So as I mentioned, we have a law forum that has been meeting and discussing this for some time, and we have a grant to develop this statewide policy for those instances in which it is unavoidable that we need to make amendments. And again, this is, we're focusing a lot on the big triggers, the change of purpose, loss of conservation value, the self-dealing, private benefit, those kinds of things that arise. I won't go through our whole process, but we have the room is a group of attorneys for the most part, both from land trust, from public agencies. We're dealing with two different divisions of the Attorney General, our charitable division and the land division. And their views are not necessarily the same about this. And even amongst the other public agencies, this has come as a great shock to them. They cannot believe that the Attorney General has anything to say. They're the ones that should have to approve any amendments to easements, and it's their sole authority. So we have very robust conversations and debate. A lot of concerns have come up. But again, I think it's because we are figuring out what does this mean to hold conservation easements in the long run? What does it mean to protect these conservation values in light of changing circumstances and imperfect documents? And finally, I'll just mention also that we've had a lot of discussion also about the worst case scenario and a hope that the Attorney General's involvement could help as well. So far, we've had really good defense of conservation easements, and in those cases where it was just purely private interest, the land trust have vigorously defended those easements. But in the cases like this, the one that I mentioned, another one where you have an adjoining landowner, the land trust is holding firm, but an adjoining landowner bringing in congressional pressure on the land trust and our state legislators pressuring the land trust to amend that easement because his intake valve is getting a lot of sediment. So, so far though, that is not where we're having the issue as much. We are identifying and have identified and are working on, and there may be more added to this list, sort of some key tests in terms of the Attorney General oversight. And in light of their resources, they do not want to get involved in the day-to-day management of easements, a lot of the administrative decisions that happen, but where questions about conservation values, conservation purpose, private benefit, other financial issues, and then also these questions around that we've got to deal with in California around other authorities to approve easements, the standing capacity, other competing interests that some of the holders, especially the other public agencies, have. We also see a need, and I don't know how this is going to quite work out, but in terms of when there's a net, or are we trying to evaluate the impact to the conservation values? That worst case scenario I talked about, I don't know. Many people they brought in a lot of scientists saying it's better for the kit fox to be, running around under these solar panels as compared to having a 100-acre gravel pit, which doesn't exist but might someday. And so the agency in question in the end was kind of forced to this decision, but concluded conveniently that the definite solar panels for 40% of the property was a better conservation outcome for the kit fox. Obviously, there are going to be times in the balancing of those conservation interest that there needs to be some independent evaluation there, and the expertise of the Attorney General is a question that they have in terms, and there's some lack of capacity and expertise for some of the questions that we anticipate may arise. That may be why it's helpful to bring in other divisions of the AG's office, like the Lands Division, or perhaps some kind of independent process, not to make a final determination, but just to look at those trade-offs that can be critical long-term for whether that conservation purpose of that property continues to be realized. We've seen a lot of kind of tiers, like in New Hampshire, kind of leading the way with tiers. And again, I do not want to provide a lot of detail given the negotiations that are going on around where things are. But we're looking at, as we've seen from some of the other cases, is where are there times that there's no effect, say, on the conservation values in the easement, or where there is some effect, but it is either neutralized or has a better conservation outcome. And then where is those extreme cases where there is an effect on the conservation values that in no way is mitigated or compensated for and results in some net loss. The same thing can be said for private benefit and these other issues. The working group that we have, and our view is that no credible and informed land trust or agency would bring forward the third tier issues or propose themselves to allow those kinds of amendments. So in conclusion, and I'm concerned about time, let me just say, as we've all talked about today, these are not simple creatures. This is not a museum painting hanging on a wall. We are very concerned and anxious to get ahead of the curve, if you will, and work with sort of the reality in California of the agencies of our multiple divisions of the Attorney General's office, make sure that whatever we do is consistent with what would work for the IRS for those cases where easements may be donated, but that this may vary, we think, from state to state, and this is a very active debate, and I think that with some real questions about how do we both protect these resources and have a tool that can survive over time and meet the challenges that we know are coming. So thank you.